Hi, Lyssa deHart here, and today we're going to start looking at the fourth part of the ICF Code of Ethics, which has to do with ethical standards for ICF professionals. We're only going to look at two elements of this particular part of the ICF Code of Ethics, and these are the updated 2025 ICF Code of Ethics. So let's take a look at all 5 of the sections under this part. And this includes agreements for clients and/or sponsor engagement, confidentiality and legal compliance, professional conduct and conflicts of interest, delivering consistent value, and professional integrity and accountability. But again, for this video, we're just going to start with the first 2. So let's get into it. I would like to share with you a number that just blows my mind, which is right now, 37% of you have subscribed to this channel, and for that, I am grateful. But that also means that 63% of you who are watching this content have not yet subscribed to the channel, and that is a number I would like to change. If you're enjoying this content, the simple, easy thing you can do to help sustain the work that I'm doing is to subscribe to the channel. So I want to thank you in advance, and let's get back to the video. So let's look at the first element of this fourth part of the 2025 Code of Ethics. And this has to do with agreements for clients and/or sponsor engagement. This is probably the shortest of the elements, so enjoy this, but it really has to do with how are we communicating with our thinkers, with the client who may be the sponsor, with about what coaching is, the relationship, issues of confidentiality, financial arrangements, and other elements of what is coaching, to include things like, what is my role as the coach? What is your role as the thinker? What is your role as the sponsor? And how much is this going to cost? And that leads into the next element of this particular section, which is respecting that for all parties to end the coaching at any time for any reason. And so what is your refund policy, and how do you navigate that should somebody start coaching, and how you either refund their money or keep part of it, or what are the agreements that you've written into your contract. And I think this is really important, because we really need to be having contracts, not just like, all right, we're in agreement, we're coaching, but rather we need to have this stuff laid out. So when I think about communicating before coaching with everybody, we really need to make sure that these contracts are well thought through. There are attorneys who specialize in contracts. There are several that I know of who work with contracts for coaches specifically and other helping professionals. And I'll put one of them in the link below, not an affiliate link, but just somebody who I respect. And they can maybe send you to other places that might be useful if they don't have the resources for you. But I think it is really important that we have clarity in the contracts that we are writing and agreeing to in the work that we do. It will make your life so much easier. So the second part of this particular area of the fourth area of the ICF Code of Ethics is around confidentiality and legal compliance. And it has 8 different elements. We're going to go through the first 4, and then we'll go through the second 4. But the first 4 are: maintain the strictest levels of confidentiality with all parties involved, regardless of the role I am fulfilling. Have clear agreements about what information is exchanged and who it's exchanged among all parties involved during a coaching engagement. Have clear agreements with the clients, sponsors, and other involved parties about what confidential information you may need to disclose with the appropriate authorities, i.e., illegal activity as required by law, valid court subpoena or order, imminent or likely risk of danger to self or others, and how we are maintaining, disposing of any records, including electronic files, communications, in a manner that promotes confidentiality, security, privacy, and complies with applicable laws and agreements. So this is where it's really the onus is on you as the coach to make sure that you understand first what are those requirements for you where you live. So if you live in, Washington State, talk to somebody in Washington State. If you live in Canada, talk to somebody in Canada. If you're in Africa, the Middle East, or Asia, you're going to want to talk to people who know what the relevant laws are that you're responsible to within that area of practice, so that you have clarity about that. So strictest levels of confidentiality with parties involved is really important. It's saying that I'm upholding these ideas of confidentiality, but I don't know what the strictest level of confidentiality is unless confidentiality is spelled out, which is why it has 2.2, 2.3 involved here. So we need to have clear agreements in our contracts about what information is exchanged and how it is exchanged amongst all the parties. So for one engagement that I was in, I've been engaged in many, but these two really come to mind. In one, there was an agreement with the organization that I was working with and the organization that had hired that organization to do coaching. But the information on confidentiality was pretty vague, and I didn't do it. I was new to coaching and I didn't do as good a job of getting real clarity around what the limits of confidentiality were. Luckily, there were no problems, but you can see if you don't really know what the limits of confidentiality are and you're working for an organization who has a contract with another organization, and you don't know what the limits of confidentiality are, something could happen and you wouldn't even know that you needed to report that or that it was okay not to report it. So getting that clarity is super important, regardless of the role that you're fulfilling. I think this is the other part too. Having clear agreements with the sponsor, client, and other involved parties about what confidential information may need to be disclosed to the appropriate authorities. The appropriate authorities may be the organization themselves. So what is the clarity that you have about where your limits of confidentiality are? So in the second organization that I was working with, that they had really clear understanding about what information would be exchanged. So I met with the client to begin with. We decided we would work together. We were a good fit. They did an assessment. We talked about the assessment. And from there, we developed 3 primary goals that they would be working on in the engagement. Then they took those back to their manager. And when they got them back from their manager, they had rewritten and kind of shifted some things around so that the goals were really in alignment with what the supervisor, in this case, the vice president of sales, wanted to see in this director. And so we had clarity about the goals. Then we met all 3 of us together to make sure we were all in alignment. Then we did the coaching engagement. And in midway through, we had another 3 of us sitting down, having a conversation. And then we had a final sit down and conversation. It was really clear how that was going to go. And it made it really simple. The manager was not worried. They were staying enough engaged as a result of the fact that they were meeting with the thinker and myself on 3 different occasions, that they were having conversations with the thinker through this process, and they were able to report out the changes that they were observing in the person that I was working with. So it was really clear, and it just made it really simple. So having that all clarified and written out made it so much easier than it could have gone in the other one if something had gone wrong. I think this is really important also. Where's the line in the sand on illegal conduct or activity? I mean, is taking a pen from work, or is using the company car for personal time, or is, taking a pack of Post-it notes home for your kid, is that considered illegal activity? Maybe, maybe not. It depends on the organization. So when you're going to be working with an organization, and maybe it's with a coaching platform that's working within an organization, I would be asking, what are the limits of, like, what is considered illegal activity if I hear it? And I need to make sure that I'm communicating that to the thinker when we're meeting, so that they know ahead of time, like, these are some of the things that I may need to tell your supervisor about or tell your organization about, should you disclose them to me. Nobody wants to get surprised by something that's going to get them in trouble. It's just not a fun way to wake up in the day. So also, what's required by law. Coaching is not a level of confidentiality that has privilege. So that means that if you're, say, a doctor, a lawyer, or a therapist, if you get subpoenaed by a court of law, you have a right to say, I will I'll write out something, but no, you may not have my notes, and you may not have the full record. That's to protect the client. There's the client, so that they're protected. But we don't have that as coaches. So if you get subpoenaed by a court of law, and let's say you're working with somebody, you're working on team stuff, you're working on leadership stuff, but as often happens in coaching, life shows up. And so they're talking about, they are starting the process of getting divorced from their spouse, and there's a lot of contention there. You never know if the spouse might decide to tell their attorney that their soon to be ex-spouse is in, coaching through their organization, and that your records may be subpoenaed by a court of law. You don't have a clue. So you need to make sure that you are telling people that my records do not have client privilege. So please, please, please be mindful about what you share, and let's not get off on a topic of talking about how horrible, terrible, awful your ex is. And then there's the issue of, like, safety. So harm to self or harm to others. I fit child abuse very fully under this, but also as a clinical social worker, I'm a mandated reporter. So I'm just really clear in my paperwork that these are the areas in which I will not, under any circumstance, maintain confidentiality. I'll tell you what I'm going to do, but I will be doing it. I'm not going to maintain confidentiality under these elements or circumstances. And then this really brings us to, how are we storing, maintaining, disposing of records, including electronic files like emails, and in what manner that promotes confidentiality, security, and privacy, as well as complying with laws and agreements. So if you have a clinical licensure in one area, but you're coaching, you might need to talk to both boards as far as what your limits of confidentiality are, but also how long you must maintain your paperwork. You may need to hold on to it longer than, say, 6 months after an engagement with a normal coach working with a normal client. So find out what is true for you in your situation, but how are we maintaining confidentiality? And so that may be two-factor authentication. It may be that your records are kept on a private server versus a server that could be broken into. Also, when I was taking insurance, I had to take a name, a birth date, and a social security number. And as a coach, I don't do any of that. So I think that's a great degree of confidentiality also. So you may get the name Jane Doe, and you may hear a few words like, I don't know, confidence or imposter syndrome, but you're not necessarily going to know how to get a hold of all of Jane Doe's information. So, but knowing how you're doing this and communicating that with the people that you're working with in your agreement is really important. Excuse the quick interruption, but I wanted to make sure that you knew that you were invited to my monthly Coaches Q&A. It happens every third Monday of the month, and we talk about all things coaching. We talk about coaching demos, we talk about competencies, we talk about what to do with resistant clients, we talk about all sorts of things. Plus, we have an added networking event at the end of it. So you are invited to join this community. I would love to see you there. And on that note, let's get back to our regularly scheduled programming. And that really takes us to the second slide, which has the remaining four elements of this particular section of part 4, which is fulfilling ethical and legal obligations in coaching clients, sponsors, colleagues to the greater public at large through technological systems I may utilize to include coaching tools, databases, platforms, software, and artificial intelligence. I recently was having a conversation with somebody about ChatGPT, and I don't do this, but I mean, I can imagine that sometimes people are like running their notes through ChatGPT to clean them up or to get out the points, or maybe you use something like an AI note taker or Fathom. How long are you keeping these things? Who has access to them? These things are making notes. They're cataloging stuff. On ChatGPT, if you've got it made so that you can share your information for the purpose of machine learning, that means that your stuff may be going out to a wider audience than you even realize. So if you're in any way keeping client information on ChatGPT, you might want to make sure what your lockdown protocol is on your ChatGPT. We're also recognizing that software gets broken into, emails get hacked. There's probably not one particular system that is 100% foolproof, unless what you have is a hard drive underneath your desk that nothing leaves and has no way to the internet. And very few of us work like that anymore. So how are you protecting your paperwork, and how are you being responsible to that? There's also that the people that are working for you have signed something saying that they'll maintain confidentiality if they have access to any information that is considered private. So people's names. So my assistant has access to my calendar. And so if she can read the names on that calendar, she needs to have signed something saying that she will maintain confidentiality and won't just sort of share, hey, Jane Doe is seeing Lyssa on Thursday too. That way it stays clean, and that there is a level of protection that is written that states that the people who can see who you're working with will maintain confidentiality on that. Also, I think, and this is, I think I mentioned it, maybe I did a minute ago, but if I didn't, I used to, when I took insurance, I would take people's name, birth date, and social security number. But even though I'm no longer doing that, and it does protect people, I still am going to often have, whether it's an email address, a full name, I may have more than one email address, I may have phone numbers or WhatsApps. And so how are we clarifying how that information might be used? So for instance, when I was going for a credential, I needed to have names and phone numbers and time frames that we worked together to show that I had the hours that I needed. So I had conversations with every single past client that I was using on my Excel spreadsheet, even though what I was doing with ICF was just attesting to a certain number of hours. I still needed to have permission from those people so that should ICF need names and email addresses to check that I had actually done the coaching I said I had done, that I could then share that information. So I think it's really important that we are being very transparent with people. Transparency runs throughout the ICF Code of Ethics. And then this final part has to do with complying with copyright laws and recognizing and honoring the contributions and intellectual property of others, and only claiming my part of the material. And I started doing the credentialing lab for the ICF exam back in August of 2022. I think I was the first person doing it. And I was coming up with acronyms and different ways of thinking about this exam. And people then started doing their own videos on this exam, and I would find my material showing up in their videos without any attribution to me. And so I think it's really important that what we're doing is we're making sure we know where information is coming from. This is true if we're writing an article, writing a book, or doing a YouTube video, that what we're doing is we're being very clear in acknowledging where this information is coming from. I didn't just manifest internally this knowledge about the ICF Code of Ethics. I'm reading it and reading different interpretations through ICF and coming up with my own understanding of it. But I am not saying that I developed the ICF Code of Ethics. I'm very much giving them credit for the fact that this is the Code of Ethics that ICF has come up with. So on that note, these are the two that we are parts that we're going, or the two sections of this fourth part that we're going to cover in this video. I hope it was useful as you start to think through the elements of the Code of Ethics. And please leave comments below, like, share, all the jazz. And until the next video, happy coaching.